Welcome to Middle Class Matters Business News in English from Dr. CMA Allegation on SEBI ruling in the case of Subash Chandra, Chairman, Punit Goenka, the Managing Director of ZEE Limited, how the funds have been diverted, 200 crore funds have been diverted, and these two people have been debarred by SEBI from being directors or key managerial personnel in any of the companies associated with ZEE or merged or demerged entities of ZEE Limited, including Sony, which has merged with ZEE. Next part continues. Reply of the entities. The entities have denied the prima facie observations made against them in the interim order. Majority of the submissions made by the entities in the written submissions are on similar lines, and the same are summarized together below. Further, the submissions of the entities that are specific to them are summarized separately. The common submissions of the entities are as follows. 9.1. The interim order must fall because it had relied upon information which was gathered during the course of settlement proceedings, which is contrary to the established provisions of the SEBI Settlement Proceedings Regulations 2018, hereinafter referred to as Settlement Regulations. 9.2. The interim order must also fall as reliance has been placed while passing the order in the matter of Shirpur Gold Refinery Limited, to which the entities were not a party to, with no notice given to the entities and no opportunity of being heard given to the entities. 9.3. In the given facts and circumstances of the matter, there was no urgency in the matter after 4 years approximately, which justifies passing of the interim order. There are no cognizable evidence which at least indicate towards the continuance of the offence. 9.4. The direction issued in the interim order is punitive in nature, which is beyond the scope of section 11b. Therefore, it cannot be issued and should be withdrawn. 9.5. SEBI does not have the power under the SEBI Act to direct the entities to cease to hold the position of a director or a key managerial personnel in any listed company or its subsidiaries. Further, SEBI does not have any explicit powers under Section 11(4) of the SEBI Act to restrain any person from acting as a director. Therefore, the directions issued by way of interim order is beyond the powers of SEBI enshrined in the SEBI Act and is also ex facie in contravention of the provisions of the Companies Act. 9.6. It is submitted that the bank statements by themselves can never lead any reasonable person to arrive at a conclusion that any transfer of money reflected in a bank statement is or is not pursuant to any sham entries or on account of circuitous transactions as is alleged in the interim order. 9.7. There is no evidence available on record to prove that fund transactions were mere bogus book entries without any consideration. Hence, the burden of proof has not been discharged in the matter. Rather, SEBI has put the onus on the entities to prove the negative. 9.8. No material has been provided in the interim order pertaining to dealing in securities or inducement to deal in securities or impact on price or volume, etc. under PFUTP regulations. Hence, framing of charges under the PFUTP regulations are very general in nature and do not make out any specific case containing necessary ingredients required to constitute these violations against the entities. 9.9. It is submitted that the regulation 4(2)(f) of PFUTP regulations uses the word knowingly, which means that it is mandatory to prove mens rea or intention on behalf of the entities to bring the violation of the PFUTP regulations. 9.10. The reference made to the movement in the share price of ZEE Limited during the financial year 2018-19 to financial year 2022 is misplaced in the given facts and circumstances of the case. 10. The submissions which are specific to entity number 1 are as follows. 10.1. Entity number 1 had issued the LOC in his personal capacity as it is not on the letterhead of ZEE Limited. At the time of issuance of LOC, entity number 1 was only a non-executive chairman who was not involved in the management of ZEE Limited and was not even an authorized signatory for ZEE Limited's banking financial operations. Therefore, LOC did not create any liability on the assets of ZEE Limited. 10.2. The LOC was not in the nature of a guarantee or therefore could not have been interpreted in that way. 10.3. The LOC was issued for the loans outstanding, specifically in the SL Green Mobility Limited. Hence, the appropriation of fixed deposits of ZEE Limited by Yes Bank Limited for 7 associate entities was without any authorization. 10.4. Entity number 1 is not associated with ZEE Limited or any listed company and therefore the interim order serves no purpose. 10.5. The interim order is factually incorrect in stating that entity number 1 was a KMP in ZEE Limited. The annual report at page 60 specifically records the name of KMPs during the financial year 1920 and the name of entity number 1 does not appear in the list. 10.6. The interim order fails to appreciate that entity number 1 is at the first place already not in any position to violate the directions given by the impunged order. He has resigned since August 2020 from ZEE Limited and currently does not hold a position in any public listed company. Hence, direction against him should be revoked. 11. The submissions which are specific to entity number 2 are as follows. 11.1. Entity number 2, being the managing director and chief executive officer of ZEE Limited, has taken appropriate steps and put in measures and checks in place to ensure that the allegations as made in the interim order cannot be repeated in future. 11.2. There is no correlation between directions passed in interim order and the violations observed, making the interim order excessive and manifestly unreasonable. 11.3. There is no evidence to demonstrate the role of entity number 2 in the issuance of LOC and the wrongful misappropriation of said LOC by Yes Bank of India. 11.4. The very first bank transfer of the monies by ZEE Limited and or its subsidiaries to the recipient of the monies was for valuable considerations. Hence, the question of all the remaining entries appearing in each of the instances is of no consequence, as the same has caused no loss to ZEE Limited. In any event, entity number 2 cannot be asked to explain the transaction beyond the first instance and those which he is not connected with. 11.5. Entity number 2 has explained the transactions that have taken place between ZEE Limited and or its subsidiaries with the entities with whom the former had fund transfer in the first instance as being bona fide business transactions for due consideration. Further, there are instances where the money which has come back to ZEE Limited is either more or less than the funds allegedly circulated. 11.6. All the transactions were backed by proper documentation, MOUs, addendums, agreements and invoices, and were duly approved by relevant authorities as per the financial authority matrix. The audit committee also approved transactions with related parties. 11.7. As long as ZEE Limited has made the payments towards valuable consideration, subsequent utilization of funds by the other parties to repay ZEE Limited does not constitute diversion of funds, nor does it cause any loss to ZEE Limited. 11.8. In regards with the related parties, it is pertinent to note that entity number 2 in no capacity was in control of the day-to-day transactions and had neither any access or right to operate the bank statements of the alleged associate entities. 11.9. Entity number 2 has never been involved in the operations or financing or control of the borrower entities. Hence, there is no case made out against entity number 2 of having benefited from the impunged transactions. 11.10 Since all the transactions are genuine and legitimate, there is neither any misrepresentation in the annual reports of ZEE Limited nor any false submissions has been made to SEBI. Therefore, entity number 2 has not violated provisions of LOD or regulations. 11.11 The continuation of directions against entity 2 will have deliberating effect on the affairs of ZEE Limited and on the proposed restructuring transactions. Hence, it is prayed that either the directions against him should be revoked or alternately pending final order, he may be allowed to continue holding his position in ZEE Limited and other listed companies. 12. Entity number 2 via email dated August 9, 2023, while submitting that the information sought is beyond the scope of the interim order and that no liberty was provided by Honorable SAT to SEBI for seeking additional information inter alia submitted as follows. 12.1 Seeking of additional data goes on to substantiate the claim of the entity number 2 that the interim order was passed in haste without there being any urgency in the matter. 12.2 SL Green Mobility Limited became aware about the misappropriation of ZEE Limited fixed deposit by Yes Bank Limited when it was brought to its notice by the accounts team, its consultants, on or around September 17, 2019. 12.3 Entity has submitted GST filing details by Pan India Limited on Couriers Communications Private Limited. Findings and considerations. 13. Before dwelling upon the prima facie findings, submissions and the directions issued in the interim order on the basis of material available on record, it is relevant here to clarify that the present proceedings before me are in the nature of confirmatory or modification or revocation of proceedings during which the assessment of the following is required. Primary issue. 13.1 Whether the entities have been able to refute the prima facie findings of the interim order with cognate evidence that necessitates modification or revocation of the interim directions issued against them. Please like the video, subscribe to the channel, share to your friends as a dissemination of information. Those who are investing in the equity market to be careful before investing in companies. Thereby they will not risk their investment. Thanks for watching.